Matter of Gonzalez versus Annucci. Counsel.
May it please the Court, Esther Merducaeva for the Acting Commissioner. May I reserve 2 minutes for rebuttal?
You may.
Thank you. The Third Department's decision should be reversed for 3 reasons. First, the Court erroneously applied the mootness exception to reach the merits of Mr. Gonzalez's claims. Second, the Court imposed an extra statutory obligation on docs to provide substantial housing assistance. And third, the Court disregarded the record evidence of the extensive assistance that docs did provide to Mr. Gonzalez, including assistance that ultimately secured Mr. Gonzalez a residence in a SARA-compliant shelter.
So let's start with the mootness issue. What's the standard for looking at whether or not they have erred in applying it?
Certainly.
Standard of review.
Yes, Your Honor. The exception to moot. Whether a court correctly applied the exception to mootness doctrine is a question of law, because the exception only applies if all 3 Hearst factors have been satisfied. So applying the exception in the absence of the Hearst factors would either be an error of law or an abuse of discretion as a matter of law. And, and this Court has jurisdiction
So why
to
is
reach
it an
that
abuse
question.
of discretion?
The reason it is an abuse of discretion in this case is that at a minimum, these issues are not evading review. And the reason that we know they're not evading review is that similar issues are being litigated in trial courts. Mr. Gonzalez's brief describes numerous Article 78 and habeas petitions that have reached these issues on the merits. There is a currently pending case in Albany County that is resolving similar questions, and that court has scheduled an evidentiary hearing, and extensive discovery has been taken in that case. The appellate divisions have, in fact, reached cases on the merits involving the conditional release and housing assistance issues. And since this case has been briefed, the Second Department has reached the merits in 3 cases and RTF-related cases involving different issues. But those cases show that these types of issues can be adjudicated both in the trial court and the appellate division in a timely fashion. So the fact that these issues are not evading review means that the Hearst factors simply have not been met. In addition, the Hearst factor, which requires the issue to be substantial or legal in nature, significant in nature, has not been met. As we explain in our brief, the disposition of all of these questions is a fact-specific inquiry. The question is whether docs has satisfied particular duties in particular individualized factual circumstances. The disposition of those claims involve applying law to facts, but that means that the disposition will not be binding in every future case. Where this Court has previously applied the mootness exception has been to legal questions, such as whether mental competency is a condition precedent for a parole revocation hearing. The Court's disposition of that issue would be binding in the same way in every case going forward, in a way that a disposition in this case simply would not be. And for that reason, the Third Department erred in applying the exception to even reach the merits of these issues.
Okay, so let's move forward then. Assume we don't agree with you on that, then what?
Certainly, and I'd like to start with the merits of our appeal, which is on the housing assistance issue. The Third Department's housing assistance holding is flawed for a number of different reasons. The Third Department both misstated the correct legal standard and misapplied the legal standard to the facts of this case. With respect to the legal standard that the Third Department articulated, the Court erred in stating that the standard is substantial assistance because the term substantial does not exist in the statute. And the Court also erred in implying that docs' assistance is a primary obligation to identify potential residences in the first instance. The legislature was very specific in using the word assist, which has a dictionary, a definition, and a common understanding of being a secondary duty.
So what's docs' position as to how much you have to do? Put aside that you might do more. What's the bare minimum you have to do to satisfy the standard as docs interprets the statute?
Certainly, Your Honor. The docs' position is that assist means that docs must investigate and approve residences and provide sufficient resources to the offender so that the offender can identify and propose residences in the first instance.
So what would those resources be? What's the bare minimum you have to do?
Well, Your Honor, it's hard to answer that question because the steps that docs takes to provide assistance of a particular type and not provide assistance of a different type is a question of reasonableness. And that reasonableness must be evaluated in light of the circumstances. Yeah, but
there has to be some categories. Like in resources, does that mean you have to give them a list of agencies? There has to be some meaning. It can't be sort of, well, it depends on whatever the individual needs. Across the board, individuals will need particular categories. So give me some sense of what that would mean.
So one sense that I can give is going through the assistance that docs did provide in this case to Mr. Gonzalez, because that assistance was sufficient and meaningful and affirmative. Doc staff,
By the way, is that the standard? It has to be meaningful assistance?
well, it has to be sufficient to satisfy the statute, but in this case,
But you've used meaningful. Why did you add that word?
I use the word meaningful because what the third department appears to imply is that the assistance would not be sufficient unless it resulted in Mr. Gonzalez securing a residence. And we disagree that the standard is only met if a person secures a residence.
Does docs have a map of New York City that shows what areas would be SARA compliant?
Your Honor, docs has an algorithm that it has access to where you can input an address and determine if an address would be SARA compliant. The reason why maps are not necessarily a reasonable alternative is that this is a situation in flux. If a new school opens up or if a daycare center opens
But
up.
why not simply take them, someone who's eligible to the DHS in the city directly before their maximum time expires, and then they're going to be in a SARA-compliant facility within the city of New York. Why not just do that?
So, Your Honor, the reason why that is not a reasonable alternative is that DHS, the New York City's Department of Homeless Services, is in constant communication with DOCS, and DOCS knows that DHS is only making a certain number of beds available in SARA-compliant shelters at a given time.
So if someone who needs a SARA-compliant residence shows up, what are they going to do? They're going to turn them away?
Your Honor, I can't speak for New York City. New York City is not a party to this case. My understanding, based on DOCS's communications with DHS and the way this partnership has been administered, is that DHS will only make a certain number of beds in SARA-compliant shelters
Yeah, I understand, but what
available.
you have already made a decision not to allow someone to go directly to seek this assistance on an understanding with the city, without knowing what indeed, I think this is what you're saying, without knowing what indeed might be their practice, policy, their legal obligations.
Well, the question of how New York City interprets its legal obligation is a question that is presented for New York City, but DOCS's understanding
No, it's
is
for
that
you, because if you've decided, well, our understanding is they won't make a bed available and they'll let us know when there's a bed available, and therefore we hold them, you're making that decision based on what you believe is going to be what they do, and the next part of that would be that what they do is indeed appropriate under the law, that they could indeed not provide these services.
Well, the level of assistance that DOCS would have to provide in any given case would have to be reasonable, and it should not be futile if DOCS's view, based on what DHS has communicated to DOCS,
You know,
is that
I do recognize it's a difficult thing to judge that. I think, to be fair to you, I think that it's to judge what amount of assistance is reasonable and fair. One of the ways of looking at it, though, would be to say, how successful is the system that we have right now? In other words, is it working? Is it doing what it's supposed to be doing? And that's what I struggle with here, because I've been to a number of the prisons. I recognize the nature of both the seriousness and the difficulty of the job that DOCS has. But you have to wonder, this system that they have just simply isn't working. It's not solving the problem administratively that the agency has. And in that situation, wouldn't it be clear that you have to step up your game, alter the way that we've been approaching this?
Well, Your Honor, I think in this case, the assistance that DOCS provided ultimately was successful because Mr. Gonzalez
Maybe it was or
released.
it wasn't in this case. That's a fair response. But what I'm wondering is how many people are actually affected by this right now?
My understanding is that as of October 1st, there are approximately 175 individuals in our
But is that
camps.
just Sarah?
These are individuals who are subject to SARA, and
But whatever your obligation is, however that is expressed in legal terms, that doesn't just apply to people subject to SARA, does it? Doesn't it apply to everyone who is released
That's correct.
Community supervision?
The obligation under subsection 201 sub 5 applies to all individuals on community supervision. This particular problem has arisen as a result of SARA's application and the limited availability of housing in New York City, where many of these individuals hope to return.
Can I just ask you this? Could you solve one problem, maybe not getting housing faster, but the good time credit problem? Why can't these inmates be transferred to the residential treatment facilities when their conditional release date comes up?
So, Your Honor, I have a couple of answers to that. One answer, and this really highlights our mootness concerns here, is that DOCS now has made the shelter waiting list available for individuals who are eligible for conditional release. So DOCS's current policy is that any individual who is eligible for conditional release is now eligible for release to a shelter. And
That's to a shelter, but if there's no shelter available, they remain in the correctional facility rather than, as I understand it, maybe I'm not understanding it correctly, if they get moved to the RTF, then their post-release supervision time starts running. What's the problem with that?
Certainly, and I will answer that question, but just to finish my prior response about the mootness, the reason why we think the mootness exception is really inapplicable here is that this court would be adjudicating based on allegations made 4 years ago about policies that have changed, and this is the very nature of the prohibition on reaching giving advisory opinions.
Doesn't that work both ways? Because if you keep changing your process, then they'll never get to the court before they become moot. So, but anyway,
certainly. And to answer your question about why they're not being released to RTFs, the statutes governing conditional release are very clear that that is up to the discretion of DOCS. Penal Law Section 70.4 subsection 2 provides that an individual is not eligible for conditional release when they cannot satisfy that condition. Now, DOCS...
So let me ask this. So the individual is asked when? When are you asking them, or when do they have to tell DOCS?
So when they become eligible for conditional release.
So let's say they say, well, I'm going to the homeless shelter on the Lower East Side. That's where I'm going. That's my neighborhood. I don't have an apartment. I'm going right to that shelter.
So DOCS cannot release an individual to that shelter without confirming that the shelter will accept them.
But the reality is you don't know that until the person shows up.
Well,
That's the way the shelter system works. You don't know until they show up. A bed might open by the time they get there.
What we do know is that there are only 4 SARA-compliant shelters in the city, and DHS has taken the position that it will only make a limited number of beds available in those given shelters. And again, I don't want to speak for New York City because they're not a party to this case, but New York City was a party in the Alcantara proceeding in Albany County, and the claims against New York City were dismissed. And one of the things that New York City argued is that it also has an obligation under state law not to cluster sex offenders in individual settings because there are public safety concerns. So to the extent New York City is administering its homeless services system in a particular way that people like Mr. Gonzalez feels is not compliant with the law, those claims are brought against New York City. They cannot, that burden cannot be brought upon
Thank
DOCS.
you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors. May it please the Court. As this is a cross-appeal, may I reserve 2 minutes for a rebuttal?
Yes, you may.
For Miguel Gonzalez, Pappalardo and Pappalardo by Jill Sanders. Mr. Gonzalez should have been released on May 20th of 2014, yet he was held for an additional 8 months and 15 days in prison-like facilities.
Why is it not reasonable to hold him, or anyone, I suppose, if they haven't met the conditions of their release, one of which is to have appropriate housing?
As the judges of this bench did point out when my adversary was arguing, the condition was impossible. They did not allow him access to the New York City shelter system. He comes from New York. His crime of conviction is from Manhattan. He wanted to return to his community.
Is showing up at the doorstep, is that the only way to find out if you can get a bed?
The New York City policy, the DHS policy, is that they will house anybody who comes to find shelter. It is their responsibility to find shelter, whether it be putting him in one of the 4 SARA-compliant shelters or finding a hotel that is SARA compliant and accessing emergency funds.
Is that a policy or a settlement? Is that the way they've interpreted the law, to your knowledge, to the extent you can say?
To my knowledge, it's based on what was indicated in the briefs, that there is some sort of partnership that has been entered into between
But Doc
docs.
says that they won't do it with these inmates because they're not homeless. They actually have a place. They're either in a correctional facility or an RTF. So does your answer to that take that into consideration?
Well, docs could have put Mr. Gonzalez or other similarly situated individuals in one of the RTFs that are in New York City, in which they would be in their community and they would be allowed to go out during reasonable hours to look for housing, employment, or other programs. However, that option was not pursued. Despite docs conceding that they did have a small RTF crew at the Lincoln Residential Treatment Facility, there are 2 other RTFs in New York City, Queensboro,
Counsel,
and Lincoln.
what would, again, the question being asked of your adversary, what would be the rule? Because the language in the appellate division as to what efforts need to be taken seems to provide, let's say, limited guidance here. The efforts are discretionary, beyond the reach of judicial review, unless they're irrational, arbitrary, and capricious, and the majority could not specify the particular actions that docs should have taken. So how do we review whether they should have brought him to this facility or which facility they should have moved him in the first place? What's our standard for reviewing the efforts made by docs?
As my adversary discussed, there is a plain meaning to the word assistance, and that means to provide money, resources, information.
But what judgment how do we apply our judgment as this court to say either on a global basis the system isn't working, or to say in this particular case, you know, moving him here, that was assistance, not moving him here, that wasn't assistance? How do we review that? Unless we have to apply an arbitrary and capricious standard, which, as you know, is a very difficult standard to meet.
It is, but I think that the Third Department found it correctly that this simply checking an address to see if it's SARA compliant is not assistance. It's not meaningful assistance. It's not substantial assistance.
There were a number of other steps laid out, particularly in the dissent below, and we would have to go through each one of those things and determine that all in all, or each one, it was arbitrary and capricious not to do something else?
I think you could look at various steps that were suggested by the dissent, and any one of those that could have been used if it wasn't. Looking at it as a whole, they didn't take any of those steps. That means that it's arbitrary and
they did a number of things, at least according to the dissent, that there were a number of things they did do here. So, aside from what you've mentioned, so how do we weigh all those things and then say, in this particular case, what they did was arbitrary and capricious as a matter of law?
In this particular case, they took Mr. Gonzalez from a prison facility to a parole officer in Poughkeepsie, which was not in his home community. They had him sit with that parole officer. He said to that parole officer whether he had found new addresses or not. That parole officer was not familiar with his community. She was not familiar with any of New York City, and she did not propose any addresses except for one, which was unaffordable to somebody who was indigent. None of that can add up to assistance, meaningful assistance, or substantial assistance, certainly not substantial assistance. With regard to that substantial assistance, I believe that the appellate division did correctly identify that is what the standard should be. There's various laws that are applied to sex offenders that are not.
That's not what the statute says. So, I mean, why are we adding substantial to it? Isn't it just necessary to determine what assistance means?
Well, if we look at the legislative scheme, which this court did do previously in the Dyack case, there's various laws that apply specifically to this particular population. We're talking about SORA, SARA, Sex Offender Management Act.
But we're not just talking about them, are we?
In this particular case,
in this case we are, but how do we make a rule, given the statute that we're looking at, how do we make a rule that only applies to persons under SARA and not to all people on post-release supervision?
Because there are certain laws and regulations that apply specifically to this population.
But not the ones we're looking, well, some of them are, but those don't refer to housing so much as they do to training and employment and that sort of thing, so.
Right. So for all people who are subject to DOC's custody, yes, there is a level of assistance that must be applied.
What
Why is
form?
this different?
Go ahead, Judge.
Because it is. There's various laws referring to Chapter 568 of the laws of 2008, which specifically dealt with the housing of sex offenders. The legislature recognized that there is a special need in this particular population in which various factors have to be considered. Because it is so difficult to house this particular set of offenders, we have a countervailing duty that is imposed upon DOCs that they have to do more.
So what remedy are you asking us to make? What rule should be coming out of our decision?
That the appellate division was correct in applying a substantial assistance standard, that here they did not meet that.
See, so that means if the DOCs checks on 58 residences, that's insubstantial. But the implication would be if they check at 65, it's substantial. You see that kind of a rule is relatively meaningless, particularly for the Court of Appeals to be applying. So I'm asking you, is there a remedy here that you're asking us for?
That it has to be more than just simply the checking of residences, that there has to be affirmative assistance. Assistance refers to sharing the burden of trying to locate housing. It's not just merely checking whether an address is approved or not. It must be something else. Bringing
well,
in...
the idea...
brings us back to Judge, I'm sorry.
No, that's all right, Judge, go ahead.
It brings us back to Judge Rivera's question, which is, so what is it they need to do? Do they have to give you a list of these are 12 places that you should go look at? Do they have to give you internet access?
Judge, there was
what exactly, and this is really what Judge Fahey, I think, is asking, is what is it that constitutes substantial assistance, assuming the word substantial actually is properly read into the statute?
One of the things that would have been very helpful is when he was meeting with a parole officer, he could have met with a parole officer who was familiar with where he was going. That doesn't, that
so they
person,
should transfer him to a local facility
Yes.
down in New York?
The statute requires that a residential treatment facility actually be in the community where he intends to reside. Here he was 100 miles away from home, and he was meeting with a parole officer who was not familiar with New York City. With regard to the map, that was a suggestion.
You mean some kind of assistance that is designed to achieve, even if it doesn't, but is designed to achieve the goal of finding a SARA-compliant residence. Is that where you're going with this?
Yes, because a parole officer who works with this community will know what has worked for other people. These parole officers are aware of the neighborhoods where searching for housing may actually turn up housing. These maps, they do exist. Whether DOCS has them or not, they can be created. Provide him references to community organizations so that they can help them find housing.
So, and then how long can this go on? Right, it's difficult, you've conceded, it's very difficult to find,
yes,
especially in the city area. How long can this go on?
Well, I think that while it is true that he can be held in a residential treatment facility for at least 6 months, which is what's at issue here, there has been argument elsewhere that they can be held longer, but I don't think that was an issue necessarily in this case because he was only held under Penal Law 7045 sub 3, which was the 6-month limitation. But certainly, if he had been placed in his community in a compliant residential treatment facility, he would have been able to not only have better help from his parole officer, but also be able to help himself by going out to look for housing, by going out to look for employment.
So you agree then when his conditional release date comes up, if all he says is, I'm going to the homeless shelter on the Lower East Side, that they don't have to release him at that point? They could put him in a different placement?
I think given the unique set of circumstances that is facing all of the individuals subject to SARA, the indigent sex offenders with this residency restriction, that it's not sufficient to say that they couldn't have transferred him to an RTF just because it's in their discretion. They have made a condition of his conditional release impossible by, I don't want to say the word colluding, but entering into a partnership with DHS by which he can't access the shelter systems,
So should they have let him go to try and find a bed in the shelter, in my hypothetical?
They should have brought him to DHS and negotiated with DHS about where he was going to be put, whether it was to access those emergency funds, which are available to this particular set of offenders, or whether it was to place him in one of those 3 facilities that are in New York City, which are residential treatment facilities.
Thank you, counsel. Counsel, why wouldn't docs, when they transferred to this gentleman, why wouldn't they transfer him to a RTF in New York City?
Your Honor, the reason for why Mr. Gonzalez was placed in the Woodburn RTF is explained in the affidavit of Anne-Marie McGrath, which is in the record, and the reason is programming and staffing and resource limitations. And DOCS is within its discretion to take those issues into account when deciding where to place somebody. I think it would be difficult for this court to decide as a matter of law that DOCS cannot consider those issues in determining where to place someone, and the limitations at issue at that time made spaces in the New York City RTFs unavailable for Mr. Gonzalez.
Wasn't he an L1?
He was, Your Honor.
Well, geez, if L1 doesn't qualify for that, who would qualify? If of the universe of people you have, they're going to be an L1, L2, or L3. So let's say the L1 is theoretically the most likely to be released. Why wouldn't that person qualify?
I'm sorry, Your Honor. I don't understand what you're.
Why wouldn't DOCS
qualify for what?
Why wouldn't DOCS take the action to release that kind of person directly to DHS? If anybody would qualify, of the universe of the people they have, this person's going to qualify.
No, Your Honor, because SARA prohibits DOCS from releasing someone who is subject to SARA.
No, I understand that. But we're back to the why not simply go to the shelter and negotiate directly to release him?
The reason is that negotiation has already happened to the extent DOCS has been communicating with DHS, and DHS has informed DOCS about the number of beds it will make available. It would be futile to require DOCS to take individuals when they know what the result is going to be, because DHS has told us what the result is going to be, and DHS told the court in the Alcantara proceeding what its position is.
What's the result going to be?
In Alcantara? Do you know what the status is of that case?
Yes, Your Honor. The decision was rendered in February 2017. There's been about a year and a half of discovery. There's no evidentiary hearing that has been scheduled yet. I believe it's the plaintiffs. The plaintiffs are required to request an evidentiary hearing date when they're ready for it.
What's the result going to be that you said we already know what the result's going to be? What is that?
My understanding is DHS will not accept that person because DHS has said these are the number of beds that we have made available, and DOCS's policy to provide those beds to individuals who have been in RTF past their maximum expiration date for the longest is a reasonable decision within their discretion.
Thank you, counsel. Counsel?
Judges, I wanted to touch briefly on mootness because it wasn't something I discussed before. I know that Judge Stein brought this up with regard to the voluntary cessation. As my adversary indicated, there had been some change in policies. However, there's nothing stopping them from going back to these policies in which we're never going to get out of this situation. There are people, there are...
But let me ask you this, because... And I didn't get a chance to ask your adversary because it just occurred to me.
Yes.
Isn't there a wrinkle here by the court having converted this from a regular Article 78 to a declaratory judgment? And if it had not done that, would the mootness analysis be the same?
I think that the mootness analysis is the same regardless of what the action would be. The mootness standard is as it's set forth in the Harsh case, and then here, I think we certainly demonstrated that it's capable of repetition. I don't think there's a dispute with regard to that. While the individual cases may be very slightly different, the policies are the same regardless of the level of where they're coming from. It's applied to any person who is subject to SARA. Across the board, people are being held past their release dates. They're being held, being deprived of their good time, and they're being held in these non-conforming RTFs, which are razor wire fences where these people are wearing inmate uniforms and living in general population and not getting any meaningful difference between imprisonment and release.
They say they can't release them because they know that there's not going to be a bed for them. There's no place for them to go. They say, we already know that's the outcome. It's be futile and not within the purpose and the intent of the statute.
As to the good time issue or the RTF
I'm
issue?
sorry, on the RTF issue.
Yeah, well, with regard to that, Judge, I would submit that there's a constellation of factors that go towards what is an RTF. And here, DOCS has not met any of those. They haven't allowed these individuals to have meaningful work opportunities, educational programs. They're not allowed to leave. They're not allowed to go out and look for their own housing or employment. And they're not treated in any way that is actually really different from regular inmates.
Thank you, counsel.
Thank you, judges.